Nous sommes en audience publique.
Court officer, we are in open session, Your Honor.
Thank you very much. Can you please administer the oath to the witness? Or the solemn declaration, as the case may be.
Yes, I solemnly declare that I will speak the truth, the whole truth, and nothing but the truth.
Thank you very much, witness, and welcome to the courtroom. I have a habit of saying welcome, and I also have a habit of explaining to witnesses that it does not mean you're a stranger in this courtroom. It is a public courtroom. It belongs to the international community of which you are a part. So feel completely comfortable in the witness seat to assist us in finding out what happened. In doing that, you have heard the declaration that you've just given, solemnly declared to tell the truth and nothing but the truth. That is all that we ask of you. That is all that we require of you. It becomes easier to do that if you listened very carefully to the questions that the lawyers would ask you, beginning with the prosecutor, would ask you questions in examination in chief, at the end of which defense counsel would ask you questions in cross-examination, either beginning with defense counsel for Mr. Ruto or defense counsel for Mr. Sang. It is important for you to understand the questions they ask before you start answering them. Do your best to answer according to what you perceived personally, what you saw, what you heard with your own ears, what you felt, what you smelled, things like that. Things that you're able to give us first-hand account of the evidence as you perceived it. Try not to guess. If you must guess, inevitably, it is important that you keep it to the barest minimum and to warn us that you are guessing. But try not to guess. Also, try not to draw inferences, as in 1 + 1 = 2. I know that's a mathematical precision, but in the court of law, try not to do it. What we want would be your 1 + 1. Let the prosecutors or the lawyers at the end of it argue that that equals 2. Some may disagree. But just give us the raw information that you perceived and leave out the arguments that follow. If you do that, you would have been assisting us in our work. There is one little matter. It might seem little, but it is really very significant, and that is how you help with the recording of the evidence. Up there you will see interpreters who are interpreting what you say into the different languages of the court, and on that side are court reporters who are actually writing down what you say. Their ability to do their work well depends a lot on you. You need to speak not very, very slowly, because that will keep us here forever, but speak sufficiently slowly to enable them to do their work while still moving with some speed, if you can. That I will be advising you when you are doing it too much or too slow. But it's important for you to keep in mind that there are people who are interpreting what you say and writing it down too. It's important for you to speak then in chunks of information, in chunks of sentences, and not to string as many as 4 or 5 sentences in rapid succession together. It will make it difficult for them to follow. And also there is something we call the gap rule. That is a gap that needs to be observed between the question you are asked and you're beginning to answer the question. It also enables them to do their work well. Try and observe those. With that, I believe that we will be in a better position to understand and record what you say. Thank you. Unfortunately, you will not be on the stand for too long this morning. We will be taking our lunch break in about 7 minutes, but we thought we can ask you a few questions during that time. Okay?
Okay.
The prosecutor will then begin.
Your Honour, before the prosecutor begins, can I just crave two matters? The first is, could we have an idea from the prosecutor how long he's likely to be in chief, so that we can better prepare ourselves in terms of any disclosure of documents that we may be using? And secondly, when we were handed this bundle, relatively small though it is, we noticed that the very first document is the witness's statement to the OTP. Now, we're unclear as to the practice, but our understanding is that you, the judges, don't receive the statements of the witnesses, though there may come a time in any process when previous statements are going to be introduced or excerpts from them. But as a general principle, my understanding is that the chamber judges themselves do not receive the statements. We noticed that you did have a statement on the last occasion, so it would be helpful to us to know and to clarify the position. But in any event, it shouldn't form part of a prosecution bundle that's circulated in our submission. It's of perhaps less importance here, though I'll give way to Your Honour, of course.
On the last point first, the first question you asked would be for the prosecution, of course, how long they will take. But on the last matter, yes, we do generally receive the statements, and it is something I too have noticed in the practice of international criminal law. I remember once making that objection as prosecution counsel in Arusha, and the judges overruled the objection that they are not to receive the witness statement. And generally, it's a matter of the judges, when the need comes to look at it. The document is already there. If there's a need to refresh memory, we know what's being talked about. If there's a need to contradict, we have the material before us, so it saves time to have it in the bundle. It depends, of course, on what the party who introduced the, who put the document in the bundle, the user want to make of it at the time. It will be then that the objection will be appropriate. How long do you intend to take?
Your Honour, the indication that we gave previously, I don't know if that's been adumbrated in one of the previous sessions, the indication was 1.5 days to 2 days. I see that if we adjourn now for the luncheon adjournment, we might have just the one session left this afternoon, in which case we'll certainly be taking all the sessions tomorrow. It could be that, and how long is a piece of string? It could be that by the end of tomorrow we would have completed. I doubt very much that we'll go into the first session, or rather, I doubt that we'll go into the second session of Wednesday.
Fair enough, but you do know why they've made the request, so the more precision you can give, the easier it is.
I think it's safe to say close of business tomorrow.
Fair enough. Then we can...
Yes, that's very, very helpful. And it would be even more helpful if we could get your blessing on our disclosing documents tomorrow morning, not earlier than tomorrow morning.
We cannot give you that blessing, Mr. Hooper. You do it at your own risk. You've had what the prosecution had told you, and you've had the policy of the chamber that if you play it so close to the line and miss it, then you will be in the hands.
Well, I understand that, and we see and observe the risk on an early occasion. But in this particular case, because of the way in which witnesses have been shuffled, and the pack's been shuffled, as your honours know, it's meant that our investigatory resources have have had to be refocused to some extent, which has meant this, that we are getting relevant information, but we are getting it, for example, this morning, and I anticipate later today. And it's in those circumstances, therefore, that particularly given what my friend has said about going into some distance into Wednesday morning, that if we felt that we could provide our information tomorrow, that would perhaps serve our interests in those circumstances, and we hope would not be a risk that would jeopardize the introduction of any documents. I must emphasize it's not a question of holding things back and doing that. It's a question of resources.
Mr. Cooper, we have to stop it there. The point that I made remains the same, and we've, in the course of the proceedings, encouraged counsel to liaise and communicate with one another on these things. And we're not going to change what I said earlier, that you do this at your own risk, so we're not going to give you any blessing. Let's not argue the point.
Right, that's very clear. Thank you.
Your Honours, the clock has been wound down, unfortunately. I do think this is an appropriate moment to break for the lunch and adjournment.
It is indeed 1 minute to one. Witness, regrettably, no question, not even a single one was able to be put to you before the lunch break. But it's all right. These logistical difficulties need to be ironed out from time to time. We will now be rising for the lunch break. And when we come back, we'll go straight into your examination in chief from the prosecution. The witness will be escorted off the witness stand and then brought back at 2:30. Blinds down fast, please.